do something very unfair, Tamar, if I might, as you come up. I'm going to ask, we were talking about this on the way over. There is an event that's not necessarily in the last 2 weeks, but certainly in the last month or more, that has to do with investment companies, mutual funds, and the fees that are paid and the duty that is owed and how that is determined. And I know you've been involved intimately in that whole process, and I was reminded of it by Stefan talking about a revisitation of the preemption for national banks. It looks like the Supreme Court is on the verge of revisiting what the duty and the mechanism is for determining the reasonableness of fees for mutual fund advisors. So perhaps if you could incorporate that either in the beginning or the end of your remarks, Tamar, that would be great. Sorry for the late request.
Well, we'll see about that later. Let me start then where you finished. The case is Jones versus Harris, and the issue is Section 36B of the Investment Company Act, and, which requires or which mandates that the fees to mutual fund investors should be not fair and reasonable, but rather impose the fiduciary duty on the recipients of either fees or of expenses with respect to that, and then impose some duties on the directors of the mutual funds. In addition, it allows each shareholder to bring a personal suit in a derivative action, which is kind of unusual. So the demand and all the other limitations don't exist. So it came to the came to the Seventh Circuit, and Judge Easterbrook said, fiduciary duty, that's an old thing. This is an old case. This is an old statute. And therefore, fiduciary duty means disclosure. And then the investors can decide for themselves. If they like it, they stay. There are 8,000 other funds. They can pick what they want. He refused and convinced 5 of the judges to refuse a rehearing. What was very interesting is that Judge Posner dissented. He wanted a rehearing. And one of the reasons is that the way Easterbrook has described the situation conflicted with at least 2 other circuits. That's an invitation to the Supreme Court, which the Supreme Court would find hard to deny, and it didn't. And so it issued certiorari, and we'll probably hear what is happening. I don't think you didn't ask me about my opinion, but I'm going to give it anyway.
I knew I didn't have to ask before you.
Okay, we know each other. I don't think they will erase the word fiduciary. What they will do otherwise, I'm cautious, I'll leave that. But I think that what you suggested, Con, is correct. They are very sensitive to what has happened in the markets, and to say to investors, you know, you don't like it, just get out. Well, they found out, investors didn't like it, and they got out. Now we don't like that either. So it's not so easy to say that anymore. Now I'll return to Ponzi schemes. First, I want to announce Ponzi schemes have been with us for a very long time. They've been all over the world for a very long time. Albania had riots because of a Ponzi scheme. Romania had a tremendous such scheme, and so on. And we have had, in cases in courts, between 200 and 400 each year. So we discovered it now simply because one of the cases is a bit large and long-term, more than the usual. Usually they wind up within 3 or 4 years. But I think that the climbing prices of stocks have helped this particular scheme and perhaps other things to last much longer. So let us get this off the table. Now, one of the reasons why they are so difficult is that they are so close to real acceptable business. Every business borrows from Peter to pay Paul. Every business borrows and yet distributes dividends. So the design is not so difficult, not so different from the usual one. Besides, some people are very exuberant, very excited about what they are doing. So this is the closest to real business, to what is happening every day, makes the discovery a little harder. And of course, people will tell you now, after the fact, what should tell us that these plans or these investments may not be kosher, if I could say so. So one is, there's a use of words that are respectable, innovation that is exciting. Not for those who understand that innovation means no experience, but for those who understand that it excites you. This is something new, something that didn't happen before. And then, very hard to verify. Now, you are drowning in a lot of facts, but not the facts that are important. So, I don't know if you remember that about a few years ago, there were 8 banks that fell for such a scheme, securitizing receivables in businesses. Up to now, they've known it, but in India. And the result was that I think each bank relied on the other to have gone to India. But it's expensive to go to India, so nobody really went until payments stopped. And then they did go to India and found out that there were no businesses, no receivables, nothing. So this is typical, and not necessarily of people who are not wealthy and not inexperienced. These were experienced people. In addition, you bury the real issue in a lot of information. Typical is Enron case, which is also a Ponzi scheme. And you have then limitations. In other words, these are not offered just to anyone. You must be very special to get an invitation to invest. And Charles Ponzi knew how to do it, and others knew how to do it as well. And then there is the personalities. It's a charm and a lot of very attractive ways of dealing with people. And at the same time, there's some analysis of narcissistic personalities which treat other people like things, so manage them. And finally, there are affinity groups. One of the cases is about a group of policemen in Australia that was caught in the same thing. So you could ask yourself, policemen? Yes, they were caught up in that. So what can be done to prevent or at least protect one against such plans? Well, you have a long list and a usual list for what it is worth. First and foremost, where is the money? And that Con has said time and again, and I join him. But not enough to just say, where's the money? It's in the bank. I want a bank statement. It should be in the bank. Then, who are the accountants? And that's also not a big deal. Diversify the managers. Unfortunately, we are in the situation where we have to do that. Not one manager. A few will be healthier. And avoid the brokers who are also managers. The regulation is different. And there is a real question then. The SEC does not have, or at least until now, did not have many resources to visit even managers, let alone brokers that are visited by self-regulatory organizations. Ask for registration of both broker and advisor. And whenever performance is both high and consistent and does not have changes, worry. Whenever the lifestyle of a manager is too grand, worry. And whenever the manager gives too many freebies, free lunches, expensive trips, worry. And I think what I'm saying now is really a summary of a lot of these cases where you see time and again the same attitude and the same pattern. So legal. I left on the table a summary of 1.5 pages of the issues after the fact that involve taxation, and I will not go through it. It's complicated. The issue is, what do you do with people who have paid tax on something that they lost? And the issue is going to be, when is the statute of limitation at maximum 6 years, but suppose they paid the tax 20 years ago. Is it the 6 years? Is it the time of discovery? And a variety of other issues. What I distributed is an attempt now by the IRS to streamline some of these issues and allow the people who were affected to know their way in this morass. And I hope that this will be settled. Second is bankruptcy. And again, I'm going to shorten the discussion and leave only one issue, which is bothersome to me. According to bankruptcy law, if a person who has benefited from other people's money in a fraudulent arrangement, if that person did not prove that he or she has done everything to discover not the fraud, but the lack of fraud, then that person may have to return the money that he or she gained. Well, we try very hard to induce investors to do precisely that. And when they find out that something doesn't sit well and say, okay, I want to take my money, that is when they have to return it. So there is a real issue here of a policy issue. And I hope that it will be aired and maybe resolved in some way. But otherwise, it is fairly, there are rules about this issue and others under bankruptcy law, and we'll see how they work out. Then there is SIPC. If the people who were defrauded were in direct contact with the broker, all they have to show is that they lost the money. They get $500,000. The question is, what about the people who were defrauded but went through some feeder arrangement? Are they investors, in which case SIPC is not at all sure that they will be compensated. Besides, SIPC does not have the money. SIPC has about $4.5 billion. It doesn't have 50 billion. It doesn't have 40 billion. It doesn't have those billions. So the real question is going to be, what is the position of these other people? And then, of course, there is the SEC. How closely is it going to discover the money? And I've already been asked, how do you discover this money? Where is it? Right now, they discovered $1 billion. Well, 1 billion is not enough. Is the amount simply profits that didn't exist, or is the amount money that was actually paid? And I know that there are some people who are experts in following this money, but you have the whole world now to look at, and that's not so easy to do. And finally, you have investor litigation. The investors who would sue each other, unfortunately, those who gained without really being responsible, and those who lost without being responsible. And we haven't forgotten the feeders. Some of them were bona fide, and some of them enjoyed too much to be true. The question is, again, where are they? So lawyers will have quite a bit of business to do in this area. Thank you.
Great, thank you.